Right, a very good morning to you. Thank you so much for creating time for News Check today. We really appreciate your company as we just have a few days left to the August polls. A lot is happening, of course, on the campaign trail and on the political side. But remember, on News Check, we also talk about pertinent issues in the society. And this morning, we will be talking about the law of succession in the country, how it captures the interest of you and I, and even the children in the society in the event that a couple is married. What does the law say with regards to their property rights and how this property ought to be disposed of? Those are some of the questions that I will be asking. Even the process of filing a succession case, what are the nitty-gritties and the documents that you need to have and the procedure to follow in case you want to be successful in that? And I'll be having that conversation with Honorable Judy Omange. She is a registrar at the High Court of Kenya. Thank you for creating time for us.
Thank you. Thank you.
All right, so that conversation will be coming in just a bit. But remember, right here on News Check, we also follow up for you events that are shaping the news of the day. And right about now, I want to cross over to Kisumu County as we are joined by my colleague, Achola Simon, who is on the other side of Kenya, just to let us know what is happening this bright and early. A very good morning to you, Achola. What do you have for us?
Well, thank you very much. Indeed, we are in Kisumu County, a bit chilly. We are not used to such weather here in Kisumu, but nonetheless, we will get used to it as we go by. But today, of course, we are in the second day of the visit of President Uhuru Kenyatta here in Kisumu County. He'll be having a 3-day visit over this region. Yesterday, he arrived here at around 5 or thereabout in the evening, and the first activity was, of course, to board the train from Muhoroni all the way to Kisumu here. And his very first activity was that of commissioning the station that has actually been rehabilitated, the railway station that has actually been rehabilitated not far away from where we are. And of course, that railway station has been operational for quite some time now. You remember that last year towards December, when of course they launched the passenger train to this particular region. And remember the hype that surrounded that particular passenger train that of course was coming all the way to that particular place. So that was the station that was actually launching yesterday, and then thereafter he went to a place called Riat that is on your way to Kakamega, and he launched Dada EPZ garment industry. That is a small industry that has actually been commissioned right up in the Riat Hills, that of course will be used in terms of ensuring that all the garments that come from this region can actually find their way there. And of course, if there's anything that can actually be produced from there, then of course for the purposes of export. But more importantly, also today he will be having a number of activities here in Kisumu County. And of course, the first activity will be that of coming here, so that then he can actually officially launch the MV Uhuru 2 that has actually been under construction for some time now. But yesterday, of course, the other bit of the shipyard and of course MV2, my colleague Beatrice Katonye will be actually discussing shortly. However, we'll just focus on what he's actually been talking about when he came here, apart from of course just telling the locals here of the importance of the railway station and of course what he'll be launching today. Of course, he delved into politics also, calling on the locals to actually ensure that they come out in large numbers, so that then they can actually cast their vote next week. And I remember one of the key points that have actually been picked and have been discussed over and over again was the need to ensure that each and every registered voter in this region actually comes out and cast their vote come on 9th of this month. We understand that this entire region, the Nyanza region, which is actually considered the stronghold for Azimio presidential candidate Raila Amolo Odinga, has about 3.5 million votes. That is kissing Kuria and of course the Luo Nyanza, and that is a voter that of course the Azimio presidential candidate will be looking at it keenly to ensure that he can actually marshal enough votes from this region before he can actually move to the other parts of the country to ensure that he can actually convince them to vote for him. Of course, time is not on his side. Nonetheless, this is something that he must do if he is actually eyeing the president. And that, nonetheless, the president, after commissioning this this activity today. We also told that in the evening he will be holding consultative meeting with leaders from this region. We understand that he will be giving out a charter to a number of universities, university colleges in western part of the country, and of course that is something that will be happening later in the day, and is something of course we'll be keeping a keen eye, so that then we can actually brief our viewers and listeners in our subsequent bulletin. Nonetheless, we are expecting the president not long from now. We understand that he's just about the corner in terms of coming at this place. There have been quite a number of movements here and there, and that of course is an indicator that he will be coming anytime from now, and of course we'll be giving you details as and when they unfold from where we are. Probably just before I go back, I will try and as much as I can to tell you exactly the importance of this particular railway station that has actually been launched, and of course this MV to Uhuru that is actually being launched today. Now there's been sustained effort from the government, of course county government, in terms of just ensuring that railway station is operational. We are told that once that railway station is actually operational and can actually ferry goods from Mombasa to here, then there's also need to ensure that actually locals can actually have their goods actually going in the opposite direction. So that is what has actually been said over and again, especially to the locals, so that then they can actually seize that opportunity and ensure that they can actually tap in the opportunities that are coming with construction and launching of these particular mega projects from this region. So I'll take you to my colleague Beatrice Gatonye, who is on the other side, so that then he can actually take us step by step in terms of the MV Uhuru 2 that is set to be launched by President Uhuru Kenyatta today. To you, Gatonye.
Water transportation in this region, President. Thank you very much, Simon Achola. That is Kisumu City, Kisumu Dala for you. Quite a chilly morning here. And all in all, President Uhuru Kenyatta will be here this morning to commission the Kisumu Shipyard together with flotation of MV Uhuru 2 here today. A milestone for the country and a moment for this country to be proud, since this is the very first ship ever to be made in this country. But just to give you a little bit of the background about the ship or the MV Uhuru 1 that you see right behind me. MV Uhuru 1 was made by British in 1901, and it was run by the British colony. And this ship was mainly used for transportation of human and cargo, mostly petroleum products in this region. And in 1963, after the country gained its independence and after the British left the country, this vessel was left with no skilled personnel or even people with technical know-how on how to maintain MV Uhuru 1. So after some time, it developed technical problems, and it was grounded for over 15 years. And in 2019, President Uhuru Kenyatta called on the Navy to revamp this ship because of the need for transportation of crude oil to the neighboring countries. The same year, 2019, MV Uhuru 1 was revamped, and it was back to life, and it started its operations. And since then, it has been transporting petroleum products to the neighboring countries. And because of the increased need for transportation, water transportation in this region, President Uhuru Kenyatta last year in May commissioned the construction of MV Uhuru 2. This is a bigger ship, much bigger than MV Uhuru 1. And in the next 2 months or so, I am told it will be ready for operations. And it has a capacity to carry 22 wagons, a capacity of 2 million liters of crude oil that will be transported to Uganda, Tanzania, and other countries in this region. It is, and this places Kenya as one of the countries, #1 country in Africa to have the capabilities of building ships in this region. And this is a proud moment for the country, considering that this is the very first ship to ever be made in Kenya. It will be maintained here, the fitting is done here, and we'll be showing you more once the program here starts, and we'll be telling you more about what is happening here. And Just to tell you a bit about the Kisumu Shipyard, this is where ships will be made. And since it was launched last year in May, this yard has received requests of building and coming up or constructing 17 vessels. So much is going on here, and we'll be telling you more about this. President Uhuru Kenyatta is expected to be here anytime. Chief of Defense is already here. NMS Director is already here. CS Industrialization is here. We'll be telling you more of what will be happening. And I would want to take you back to the studio. More will be coming to you from Kisumu Dala. Beatrice Getonye here.
Indeed, Getonye, thank you for that. And it looks like you're really fitting in well in Kisumu County. We'll be crossing back to that particular county later just to get more about how the event is building up. And President Uhuru Kenyatta is expected to preside over the Kisumu Shipyard Limited and the floating of the MV Uhuru Wagon Ferry. Getonye, they are taking us through the breakdown of the background on how this all came about and why this is important for our country going forward. But remember, the president is on a 3-day working tour in the Nyanza region, which comes just 6 days to the election. We have seen him launch several projects in the region in the recent past. And just the other day when he landed in Kisumu County on Monday evening, he officially opened the new ultra-modern Kisumu railway station located on Busia Road, just next to Kisumu Cotton Mills. And of course, this couples quite a number of other developmental projects that the head of state has launched in the region. Of course, this may just be his last official visit to Kisumu County, bearing in mind that it's just 6 days to the general election. But we are yet to hear more about how this event is going to pan out and what the head of state also has to say with regards to this major milestone for the country. But in studio, we are also discussing quite a lot that touches on not just our preparedness for the general election, but also the laws that touch on succession in the country. And I'm having this sit down this morning with Honorable Judy Omange. She's a registrar, the High Court of Kenya. Once again, asante sana for creating time for us.
Thank you.
Maybe a good point to start with, just 6 days to the general election, a general overview of how you as a judiciary are prepared for this election.
Thank you very much, and thank you for having us here to talk about succession matters, amongst other things, even as we go towards the election. The judiciary is prepared. We have a committee on election preparedness, which has been working very hard to ensure that we are ready in terms of being able to process the matters within the statutory timelines. And for the last 2 election cycles, the judiciary has been able to do its mandate within the time. And we expect that even with the arrangements we put in place, this time that will happen. But we're also concerned about other cases. We are concerned that as we are going to focus on the election preparedness, we do not lose focus of other Kenyans who would wish to seek our services. So in terms of succession matters, this week, the Honorable Chief Justice has declared a National Service Week just for succession matters to ensure that we're able to fast-track them, if we may say so, before we even get into the electoral cycle. And succession matters are important because it's about what happens to your property when you're no longer there. Most people end up in the succession courts. And in the judiciary, in the High Court, the succession matters form 20% of the caseload we have. Magistrates' courts, not as much, it's 7%. But still, it's a whopping 58,000 cases when you look at it across both courts. So we are hoping that in this week, we will be able to make a dent, at least hear some. The ones we won't be able to hear, we'll refer them to mediation, so that then we are able to fast-track those particular matters.
All right, and we'll talk about more about what the law says about succession, but that is where I want us to go right about now. Later we'll talk about the backlog and how you seek to deal with this crisis going forward. But let's understand the basics from somebody who is watching this program and asking themselves at this moment, what does the succession law say about the property rights acquired by, say, a couple?
Okay, the succession law seeks to ensure that the property rights that a couple got during their lifetime and their marriage, upon the death of one of them, is transferred to the other in a very seamless process, ensuring that the rights of all other people who may have a stake are protected, mainly the children. Because, you know, the succession law indicates who are the first beneficiary. First, it is the wife, then it is the children, then you go to parents, then you go down to brothers and sisters. So the succession law just seeks to define that procedure, what you need to do for you to be able to administer the estate of a deceased. It is illegal actually to transact on the estate of a deceased who is not there without going through the courts. So the succession law seeks to ensure that that process happens seamlessly, ensuring and safeguarding the rights of everybody.
All right.
Yes.
But how much of this is considered, if you look at our Kenyan context, in terms of even awareness that such a law exists? How much of it are we adhering to this particular law compared to the local arrangements that we see in many families? How big of a problem is it? Absolutely.
It's actually a big problem, because in the first place, many people don't know that you're supposed to come to court and have your matters processed through the court. And if they do know, sometimes they don't agree on how that property should be distributed. But if they're before a court, then that is good, because the court will make a determination. But you'll find that there are some who even go ahead and sell property without going through the formal process. So you are like one, like for instance, if you have many sons, one of them sells your property, it means he has disinherited the other children, not sons, even sons and daughters, because they are all entitled. He has disinherited the other children. So there's a third buyer who has bought this property, who is now thinking he has a good title, but it turns out eventually that he will not have that title, because when the other siblings realize and go to court, the court will make a determination that that property needs to revert back to the family for distribution. So it's a big problem. A number of the land disputes we have are also because of failure to follow the proper succession process. So ideally, a buyer of such an asset, what are some of the fundamental things that they should consider before actually saying that they validly now own that particular property? It's very important that you get to see the title deed. And if there's somebody tells you this title deed is in the name of my father, that's where it ends. Because you need to tell him, if your father is deceased, you need to go to court and get a proper letters of administration that allows you now to transact on this property. And your siblings also need to agree, be involved, or even the widow, if there's a widow. You need to be involved so that you all agree on how this property will be apportioned. After that, once you get your own portion, now you can sell it. But before you get your portion, you shouldn't sell. So if the title is still reading the name of the deceased, then that's a no. Yeah, it has to read the name of the person who you're transacting this business with. Yes, you shouldn't. All right. So let's go step by step. Let's begin from before marriage. What does the law say about the property that this couple acquired before they got married? Before you got married, if you bring your property to your marriage, isn't it? I'm assuming they're getting married. Yes, they're getting married. But then you have your property. Then one of you dies. Then it becomes, unless you had bequeathed it to another person, it becomes now part of the property which will be up for distribution. Unless you had said specifically, and this is why it's important to indicate your wishes, unless you said, maybe this property of mine, I'd like it to go to my mother, for instance, or something. Unless it's written. Yes, unless it's written. But otherwise, the law will follow its course. We'll be able to look at, now you have died, this was your husband, you're legally married, then the property will be distributed with the spouse being first. But if they are minor children, the minor children are entitled for the protection. The protection must be protected for them. All right. I'm coming back to you, Honorable Mange, in just a bit. We have to understand all the grey areas. But right about now, I want us to get something that is currently underway. The Ministry of Health has developed Kenya's first suicide prevention strategy that is seen to go a long way to provide a framework of interventions to reduce suicide mortality in the country. Currently speaking is the Ministry of Health Director General, Dr. Patrick Amoth. Let's listen in to what he's saying.
Encourage them to get the much needed mental health and psychosocial support. To the parents and caregivers, this is a reminder to build on the relationships and social connectedness with our youth. Let's not forget, we were once youth, and we recognized that psychosocial support was crucial to our mental health and well-being. Collectively, we have an urgent need to respond by coming together and implementing measures to reverse and halt suicide-related deaths. Again, that is in sync with the Kenya Health Policy 2014-2030, Policy Thrust number 2, which talks about halting and reversing the burden of non-communicable diseases. The Ministry of Health is here today to respond by launching the Suicide Prevention Strategy 2021-2026 that will establish and operationalize suicide prevention program at national and county level. And secondly, the strategy will strengthen supportive policy, legal, and financing environment for effective implementation of suicide prevention programs. I'm glad that the team will continue after this event to be able to look at the benefits package that will be catered for under our UHC benefit package policy for mental health. Indeed, that will be critical if we include mental health care package that is exhaustive enough. Then we shall clearly be indicating that we are in the journey to be able to ensure that we slay the dragon of mental health pandemic. To add to that, the strategy seeks to improve access to comprehensive, integrated, and quality health services for suicide interventions at all levels of care, as well as increase awareness on suicide and suicide prevention, and address stigma while strengthening systems for surveillance and research on suicide. That fits very well in our pursuit towards universal health coverage, and our journey towards UHC is premised on primary healthcare approach with a strong community involvement, strong preventive promotive healthcare services at the lowest level of care. And therefore, if we talk of integration of mental health care services, including suicide prevention at the community level, level 2, which is a dispensary health center level, then by and large, we'll be dealing with a large proportion of our population who will be facing this challenge. And therefore, because of the measures that we put here, may not require much investment except investment in health workforce and probably a room or thereabouts to be able to offer confidential counseling services. We shall be able to make huge strides in ensuring mental health well-being of our population. To achieve this, we shall have concerted multi-sectoral approach that is public as well as private-based. I urge all stakeholders to join us in this effort to implement the strategy in attainment of a 10% reduction in suicide mortality by the year 2026. Our coming here together as a community, as a society, including the presence of...
All right, so the Director General there under the Ministry of Health, Dr. Patrick Amoth, speaking at an event that is seeing the ministry launch what it has developed, Kenya's first suicide prevention strategy, making a clarion call there to stakeholders to work together to reduce the suicide mortality in the country. The target is 10% reduction of suicide mortality by the year 2026. How practical is this going to be, and how sustainable is that also going to be? That, I believe, is part of the things they're discussing at this particular forum. We'll be getting back to that and also giving you more details about it as we continue with our day's coverage. So in studio, we are talking about a lot that touches on the judiciary, specifically talking about the law of succession and also how they are planning to deal with the backlog of cases that currently are at the different courts in the country, and also talking about the judiciary's preparedness for the elections. And I'm having in studio this morning Honorable Judy Omange. She's a registrar at the High Court of Kenya. Thank you. So I wanted us to go back to what you initially had started explaining to us, the property rights that one has under the law of succession before marriage. And clearly I wanted what to come out is if you know, both parties were single and they acquired property in their life as you know, when they were single, and then they're in an arrangement of marriage, what does the law say with regards to how much influence or how much decision they can make with regards to that property, assuming they're both alive and married?
They're both alive, you own your own property. If you bought it, it is your property. If you buy property together, then now you own that one jointly. Yes.
Okay.
But if it is your own property, you came into it, you had this land, it was registered in your name, it's registered in my name, it's my property.
All right.
Yes.
So in the event that things don't go well and there is a separation or a divorce and children are involved also in this, how does the law treat, how the property is shared in this particular context?
The law would be that the children, the spouse would be entitled to what they brought into the marriage. That one, there would be no dispute. What usually comes up as a dispute is property they acquired together. And in that, the courts have said the contribution of each party must be verified, must be proved. So you will have to go to courts. That one is a matrimonial cause. It's called a matrimonial cause for the court to determine how much of each property should be given to either of the parties. That is if you don't agree. However, if you agree, which is a good case scenario, then you just agree on how you'll share the property. The issue of children comes in. Children maintenance is a different issue from property. So we can't start saying that because I have to take care of the children, give me the house so that I take care of the children. No. What we'll be saying, we'll be looking at the Children Act, and it says each child has a right to be maintained by both parents, not one, both. And those both parents have to provide provide the child with housing, you provide the child with medical, you provide the child with education and all the basic rights. So the court will look at the earnings of each party and what they have to make a decision on how that the children are to be maintained. So it's a different issue. We have cases where people come to court saying, so-and-so owns this property and they have children with me, the court should make a decision based on that, but that is not, it has nothing to do with children. Yeah, the issue of what property you own only goes to show what you can maintain. So if you say I have money, I can pay the money for the children, the court will not mind about what property you're going away with. So long as they've looked at the initial principles, which are what contribution did you make towards acquiring this property? Yeah.
So the property that you own, that is under your name, you have to prove it that beyond reasonable doubt that you have
the property.
Yeah. What is it that is used to really confirm that this is what you got before marriage and this is what you got together as a couple? As a couple.
Ordinarily, the civil cases are decided on a balance of probabilities, meaning the court will look at the probabilities, the court will weigh. Because many people get into a marriage knowing they will stay. So maybe you might not have been looking for evidence. You might not have been keeping receipts or, that kind of thing. But you could give evidence that the court would be able to confirm. If there was a foreman I was using to do a construction, he comes to court, and says, this lady would sometimes give me money. This other one, the man would also give me this amount. Court would look at that kind of evidence. So it would be up to you, based on your own circumstances, to see, and the advice of your lawyer, to see what sort of evidence you adduce in court to convince the court you contributed. In some cases, people say, I didn't contribute anything, but I was taking care of the children.
And moral support.
I was giving moral support.
Which is important.
And that has not held so much sway with the courts. Of course, they can give you a percentage, something, but it has not really enabled them to give you to be entitled to half the contribution, unfortunately.
But in cases where perhaps maybe you were requested to resign from your job so that you can fully concentrate on bringing up the children, and then the man of the house goes ahead to now focus on development and investment and all that, how is that not counted as contribution?
No, you'd have to prove your case. You'd have to indicate before the court that you're in about how what you did enabled the man to, or the woman. Actually, I've had cases where women are being sued for maintenance, how it enabled the woman to make wealth. So it would be a case for proving. It's not taken for granted. You can't just come and say, me, I was sitting in the house, I was cooking, I was doing ABC. No. You have to, or me, I was the man, I was the one doing the house activities, taking care of children, taking them to school. You would have to prove. And how that enabled your spouse to go and look for wealth.
So let's get to where now this law really captures quite a lot, and that is upon death. Yes. And upon death, now that you've been married and then one person dies, unfortunately, what are some of the strategies that or provisions that the law provides on how to decide the share of property in that particular context?
For that one, the best case scenario and many of us, unfortunately, are not quite there yet, is that you have a will. Because if you have a will, you'll have clearly outlined, this is how my property is to be divided. And unless it was an illegal, you made some illegal provisions there, the court would uphold it. Unfortunately, many people still end up not having had a will. So then the loved ones who are left have to file what is called a letters of administration. You get some forms which we have in our courts. You need a letter from the chief. You need a death certificate to be able to come to court. So you come to court and you fill those forms, and the matter is published in the Kenya Gazette. And if nobody objects, there's no one else who is claiming anything, then you're issued with an interim letter of grant. Again, many people at the point of the letter of grant, they stop pursuing the issue. So they go maybe with that letter of grant, and then the court gives, the bank gives the money, or they start transacting on the property. But that is wrong, because that is interim. That is just to say you are the right person to administer this estate. The law requires that you wait another 6 months. And I think the period was so that if there's anybody else with a claim, to avoid selling land to someone, then tomorrow there's a claim on that land, you have that 6-month period to just gather yourselves and agree also on how the property is to be divided. Because, you know, emotions, when somebody has passed on, there are a lot of emotions. You need that time to just settle and agree. What do we do? Do we want to sell this land? Do we want to divide it amongst ourselves? What are we going to do? So within those 6 months, you're supposed to come back to court. Unfortunately, many people don't come back. In fact, this week we are listing around 6,000 cases where people have not come back to confirm. They just got the grant and they went away with it. So now they're appearing in our books as pending, but you might find those people have already even sold land based on. But we have an answer to that problem. The Chief Justice issued directions that from this month, I think last month, any grants we are issuing, we are saying this one cannot be used to transfer land, you know, and you have to come back after 6 months. So that will alert every person who comes in contact with the grant not to use it. But for the historical ones, we have a challenge. Now these 7,000 actually cases that are appearing in our records, people might have even concluded them, but in our books they're still appearing. So that's how a case is determined. If you're unable to agree, I'm talking about a good situation where you all now agree, then come back after 6 months and say we are all getting this and that and the other. If you are not able to agree, then we are in a worse situation, because now the court has to make a decision. And I'll tell you, those are some of the most long, drawn-out cases we have. People, it's 20 years, 30 years. People are in court. Not because the court doesn't want to hear, hear the matters first.
But they can't agree among themselves.
They can't agree, so there are a lot of these. The court has to make a decision on everything. Sometimes even the person who is supposed to sue, and then sometimes we decide and we think we have finished it, then a grandchild emerges. Who says, you know, the way this issue was dealt with, I was not taken care of. So they're back in court.
Okay.
Yeah.
So before I get to that point, I want to go step by step also on the process, which you have clearly outlined. So it begins by acquiring the basic documentation.
Yes, basic documentation.
So assuming there's a widow in this situation and they want to claim the property of their deceased husband, they go and they need a letter from the chief. They need a death certificate.
A death certificate.
They need
various forms. We have forms, different forms for the different types of letters of administration. There's a letter of administration where now I want to administer the estate fully up to that point where I'm talking about of 6 months. But there's one where maybe like somebody died in an accident, I want to sue on their behalf. You go for a limited grant, just asking to sue only. So the powers the court gives you is only for suing. Then there's another one where you're saying this estate might be squandered as we are here in court for 6 or 8 months. I want just a grant to help me collect the estate, so that I can go to anybody who has their debt. They can bring it here. They stop any action on it. It's called alcorigenda bond. Those legal terms of ours. So so that one is also a grant. So depending on the type, you get a form from the registry. We have those forms. You can download them on the website, and we have done a lot of IEC materials. If you look at these IEC materials, this is from the magistrate's court. It has the whole case flow process mapped out. If you look at the ones for the high court, even again, they are also mapped out. So we have a lot of these materials in courts. Right now, they're being shared in the various help desks we have across the country. They'll just guide you on the step-by-step process. So once you get all those documents, depending on the type you're doing, you're filing for, then you just take them to court and pay money.
All right. So the forms, you have to take back the duly filled forms, and then they are gazetted?
Yes.
Or
you pay, then you pay court filing fees.
Mm-hmm.
After you pay the court filing fees, there's another fee you pay to the government printers, which you deposit in their accounts. We used to have people buying money orders, and now we have said we didn't want the money orders because there were a lot of issues. You know, we have moved past money orders generally in financial management. So now you deposit it direct or bring a banker's check. Then we collect all those matters together in a registry called the Principal Registry, which is a central registry in Nairobi. It has all grants which have ever been issued. We collect all those gazette notices, take them to the government printers, and they're printed in a special issue. After 1 month after the gazette notice, then now we issue with that grant, the first grant.
So this is to open it up to the public so that in case there is any objection, somebody can raise it. So 30 days,
30 days.
So in the event there is no objection?
In the event there is no objection, then the grant is issued.
Okay.
Yes.
What if there is an objection?
If there is an objection, I like the way you're flowing with it. If there is an objection, then you go for hearing. Now the court deals with it very early. You know, already there's a problem, there's a dispute. So you'll go to the court. Now we are referring all of them to mediation. The minute there's such a dispute, we refer them to mediation. And we hope they'll agree, because we'll hear what the mediator will bring them together at a table, and we hope they'll agree. 50% to 59%, they are now agreeing in family matters. So it means if we refer 100 cases, 59 will agree. There's still the 41 where people are not ready to agree. Then they come back to court and we hear them.
All right. So there's what we call, is it a temporary letter of, even under circumstances where there's that objection, there's something I wanted you to clarify, because it's called a temporary grant of letters of administration.
Yes.
What does it mean, temporary? Does it mean that you're not fully granted that particular letter, or what?
I think you're talking about the special grant.
Yes.
Yes, there's a special grant. Someone was the breadwinner, they have passed away. The children cannot go to school. The court will not let these 8 months pass without taking care of those children. So you can come to court in a special application and say, I'm the widow, this was my husband, or I'm the widower, this was my wife. These children were relying on him. Now we can't get anything, because you know the minute they've died, everything is shut. So the court now gives an order saying maybe the bank can release this amount of money to allow the children to go to school. So that is a special one. Yes.
Earlier you were talking about a concern that you had there, that once people get this letter, they disappear. Like it's sort of like they don't go through the entire process to complete it. Talk to us about what it means to complete this entire process. What next after you get that letter? What are you supposed to do to ideally now say that the property has been successfully transferred to you?
Yes. After you get the grant, which is after 30 days, when there's no objection, ideally you should now be collecting the estate. And collecting the estate means, you know, you could have known that the deceased had maybe 10 title deeds, but you find he has maybe cars you didn't know about, there was money in a bank you didn't know about. So as you investigate all those things, if you find there are properties which need to be brought to the table, you add them. You can apply for what is called a rectification, and then it comes, the court rectifies the records. And then also you try and seek consensus amongst the family members. How are we going to distribute this wealth? This is what I found our deceased, our loved one owned. How do we distribute it? Because you'll find maybe he owned a house here, he owned another one in his home, he owned another block of flats. Does everybody want the block of flats, or how do we distribute it? So people will now share the property, agree on how the mode of distribution. It's called mode of distribution. Once you have an agreement, now you file what is called an application for confirmation, and then a mode of distribution on how it's going to be distributed, and then the court will give you a hearing date. And that is happening a lot in all the courts across the country where we are hearing matters. This is what's happening. They are confirming these matters. So when you go for confirmation, the court's main interest will be, have all the beneficiaries meaning the people who are entitled to inherit, been taken into account. So they look and see if it's someone who had 6 children, have they all been consulted, have they signed a consent? Because they have to sign a consent. And most courts would be careful and say they want to see those people.
Is there an age limit for these children who are signing the consent?
Yes, that's a good one. Yes, there must be an age limit, because if a child is below 8, above 18 is the only time they can sign a consent. But if they're below 18, we file what is called, we have 2 petitioners. You cannot petition alone. So like even if you're a widow, you have to get someone else to come and petition with you. Yeah, but if they're all above 18, they can all agree just one person to file. Yeah.
In circumstances such as in certain families, and I believe a majority, where the widow does not have the privilege of cooperation from the family members, because a lot involves you going back and agreeing as a family, from what you have explained. What about circumstances where there is no that privilege of agreeing as a family? As a widow, you really, in fact, there are third parties who want to lay claim over the property, and their family members who you should ideally be seeking consent from. What alternatives are there? What do you do in such a circumstance?
It happens, tragically it happens, because these are family members who live together. Sometimes even we're not even talking about brothers-in-laws. Sometimes even one's own children might have serious contestation about how the property is to be shared. Now in that event, then you are now, we open the doors of the court for you to come so that we resolve the dispute. And the first, again, step will be to send you to mediation, where we hope if it is a situation which is resolvable, they'll be able to resolve. And we're very hopeful. That has worked now quite a bit. But if we find it is not being resolved in the mediation, then it has to go to court. But usually it's a very long drawn out matter. Yeah, usually there's a lot of, because that anger spills over into everything. So there's nothing where people are agreeing.
Let me take you back to now the man. And in this case, how is the law capturing the issue of now the man is the one who has been left? And you know, in our African context, how the succession of the property of the wife and what you got together can actually go. So what guidance does it give in terms of how the man should, what level of influence he has on the property, and how he should, the claim he can lay on that as well?
The man also would follow the same procedure, and if it was his wife who has passed on, it would again just go through the same procedure, and usually he would be able to inherit together with his children, because his children would also be having a right towards that property. But he would be the first. It's the widow first and then the children. Yeah. Okay,
so the same procedure applies?
The same procedure would apply.
Okay, yes. But does it exempt what the wife got before? Or?
No, there's no exemption. Unless it was clear, because you see, by then they have merged their marriage together. So he will be, he's now he's the heir to the wife. So he's the beneficiary to whatever she owned.
Okay. Yeah. So let's talk about this.
But of course, if the mother or father of the wife felt that I'm also entitled, then they could also stake a claim, which the court would then look at, if they are unable to agree as a family. Because maybe the mother was depending on this daughter before she passed on. So she could also lay claim, just the same way brothers-in-laws and fathers-in-law would also lay claim, even if it was the widow who was left. But of course the court would consider, in terms of consanguinity, consanguinity meaning rights, they are really low down in the chain. But it would be a matter of evidence.
Seems like all this would be solved if people just wrote a will.
Absolutely.
Like a lot of this, almost half of it will be solved if people wrote a will. But let's talk about that document called a will. What is considered a valid will under the law? And just so people would understand, because we've had cases of a will has been forged, a will was tampered with, this will we cannot, admit it. What is a valid will under the law, and under which circumstances is it written so that it can be accepted as legal?
So long as you're an adult and you are of sane mind when you're making the will, and you sign it in the presence of two witnesses, that is a will. It doesn't even have to have a certain structure or format. So long as
it can be just on a piece of paper.
It can be just on a piece of paper. But of course, sometimes I've seen people bringing something, somebody was already in the ICU, then they have a will, now that's a bit of another challenge. But if you make your will, like right now, just saying, I have these properties and I'm saying, I want this car to go to so-and-so, this one to go to so-and-so, and then you sign and you get two witnesses. It's something, and then you appoint someone who will be an executrix of that will or executor. That is a will. That is something which will pass.
Circumstances under which the will is forged or tampered with, how do you prove that?
Yes. Again, the will goes through the same process as the one where you don't have a will. You have to fill certain forms. They're different from the ones you fill where you don't have a will. Then you come to court, you pay the fees again. it goes for gazettement. Then anyone who is now challenging at that point will now come back and say, I have an interest. This will is forged. And when they say it is forged, again, it's an issue of evidence, because they'll be proving to show, let's look at this man's signature. Was this how he was signing? Some people will be saying, and I've heard that being said a lot, you know, he was sick. This guy was sick. He couldn't have signed.
Yeah, the same way he does when he's okay.
Yeah, he was in the ICU, and these people went and stood there over him and told him, please just sign. This is not even his writing. It is so-and-so's writing. So it's again a matter of evidence, which will be proved before the court. Yeah.
Talk to us about this third-party influence and. It's illegal if you meddle. It's called intermeddling.
Intermeddling, I can see.
How it's captured in law, because this is something that is done like almost on a daily basis in our African context, so that people would understand how big of a problem this is, and what the law actually, how far the law can go in punishing this intermeddling.
Intermeddling is an offense, and if you meddle with anybody who has passed on, even if he had M-Pesa on his line. Let me break it down to that basic level.
Yeah.
You know, you have, some people have a lot of M-Pesa or even a little in their phone, and he dies, and then it is proven later on that you're the one who withdrew that money, and you knew he had died because maybe you're even going for the funeral. That is intermeddling. Because you should, essentially, that property should be declared as part of his estate, so that then the court is able to make a determination, or the parties are able to agree how to share it. Yeah.
This includes even the spouse.
Yes, even the spouse.
They cannot withdraw money.
Even the spouse. But there's a way you can get out of that noose if you have a joint account, you know, that where both of you are independent signatories. Because you can tell the bank, we're joint account owners of this account. I can sign, my wife can sign. That one, then she will continue to run it. Yeah.
Okay, let's talk about polygamy and succession rights.
Yeah.
In the event that a person has more than one wife, how is that also catered for in terms of deciding how much goes to who? Yeah, if the husband is no more.
If the husband is no more. Again, the issue would be, let's look at what whether they are agreeing. That is always the first issue. If they agree, there is no problem. But if the decision has to be made by somebody else who is not them, of course, if there's a widow there who had contributed a lot to the property that they had, the court would consider that in giving them more than they would give this other one who did not contribute as much. So it would be like the case of now the divorce. Yes. Because the court would now be the one making the decision. So this one will be saying, you know, I'm the one who struggled. We got all these things together. I'm entitled. Yes, and honestly, this other one was married after this property was acquired. So the court will look at all that and make a decision.
So it is considered.
Yes.
That is captured also.
Yes,
it will be considered for that.
It would be.
Okay. Are the children also considered in this case, or they are totally separated from the property?
They are considered. The children are also entitled to inherit.
Okay.
They are also entitled to inherit.
All
so
right.
the court would look at all those factors and then make a decision on how the property is to be determined. Yes.
So let's talk about the backlog of cases. You gave us some interesting numbers earlier.
Yeah.
About how many cases you're currently dealing with. Talk to us about that and what strategies the judiciary has put in place to sort of address this crisis.
The judiciary continues to face the challenge of backlog, which has been really an ongoing issue, but it hasn't been addressed. We have improved significantly. I just give one example from the High Court. We had a backlog of 172,000 cases in the year 2013, 172,000. Now, at the last, we usually report yearly on our cases. So I think this year we're going to release the report for last year. But the report released last year shows the High Court had 90,000 cases as at the close of the financial year.
90,000.
That's a big difference of 60,000. So we have improved, but still we have less than 1,000 judges and magistrates serving 50 million Kenyans. It's not possible really to keep up with them. So we are doing different things. We are trying to see what case management practices we can put in place to improve. But then we are also looking at what other, we have to think differently outside the box, and that's where mediation comes in. Mediation was brought in to help us because of those challenges. And like I've told you, in family matters, it is doing already very well. So far, they've cleared 3,500 cases since it started in 2016, and they're very successful. We are hoping we can get the same sort of numbers in other cases, but for now we are happy that at least family it's happening. So we have all those are measures we are putting in place. The increase in the number of judges and magistrates is also another measure. Judges have been increased, magistrates have been increased, so we are happy about that. But we are also looking at special initiatives such as this Family Service Week to deal with specific cases which can be quickly cleared within a short time. Then they leave us now to focus on the other more complicated cases. Yeah.
Talk about those more complicated cases. We are getting into an election, and this is a season where I believe if it has been a problem, the backlog of cases, then it's going to be compounded by the election petitions that maybe you're going to be receiving. Talk to us about what you're foreseeing in terms of dealing with those cases, and are you already in that space? Because it's a very crucial time.
What we are foreseeing is that people will file cases, and you know, really at the end of the day, it's good when Kenyans file, because it shows they have a dispute resolution mechanism they have confidence in. So we are working with even seeing them double maybe from what we had last time, but that is not cast in stone. That is really speculation. So we are ready. We are preparing very well through that committee, the JC. It's called JCE, Judiciary Committee on Elections, chaired by Justice Ibrahim. What they're doing, they're training the judges, training the magistrates, training legal researchers. This week, I think they're training ICT officers, because we will be trying to use, we'll be trying to see how the ICT officers can help us with case management. Remember what we talked about, just improving our case management techniques. Then they're also training our staff who will be manning the registries. They're coming up with different checklists to assist the courts as we do the work. So there's a lot of work that is going on, and I think that committee is doing its work very well to prepare us.
To save, you know, a lot that ought to not even get on the judiciary's table, just take us through what warrants a petition that meets the threshold. We're in that season, you know, I mean, just so we don't end up having so much for the judiciary to handle things that could have been prevented in the first place. Those
ones will have to be determined by the judges and magistrates when they come before them. Those ones we cannot determine now here, because the electoral laws are very clear about the petition, the filing fees you pay, and everything that you need to have in place. But as to whether it meets a threshold or not, that is what is called a judicial decision. So a judicial decision can only be made by a judge or a magistrate in each individual case, because if we generalize and say this category should not come, it means we are not promoting access to justice, which is what now our Chief Justice is telling us. We want social transformation through access to justice. So those will be determined, but the doors have to be open. We can't close the door on anybody. So the doors have to be opened. So looking at the numbers, likely to double, but that's a wait and see. You say your prediction is that this time around it's likely to double. No, that's not a prediction. I'm saying the last year, in the last election cycle, it's doubled. The last electoral cycle. So this year, we don't know what will happen. We still do not know what will happen. It's a wait and see. It's a wait and see. So borrowing from 2017, you know, what is it that you have put in place? What lessons did you, what were your take-homes in how these cases were handled that you have at least improved this time around in terms of managing this crisis? Like I've said, the committee works very hard and has been doing in terms of capacity building. This has happened in even the previous 2 cycles. They've done a lot of capacity building and also just sensitizing us. But I would say, just the way we've done well in the last 2 cycles, we will still continue to do well. We will clear those decisions within the statutory timelines. That would be my one point, that we are working hard, and the committee is working hard to ensure we are all ready. Yes. There's just a recent case that I would want you to you know, just tell us a bit about that went all the way to the East African Court. I don't want you to go to the specifics of this specific court, but just to understand the background and you know, the importance of this East African Court of Justice, because we have you know, ways in which the petition, how far it can go, how far
far it can go. But recently we saw it being taken even outside the country. It's not the first time this is happening in Kenya. Just take us through the basic understanding of the East African Court of Justice and its mandate and circumstances under which it can come in handy.
You see, the matter, of course, would be a matter that is alive in court, so we can't talk about it.
That's why I said we can't really
talk about it. But I would say it's a regional court where the parties that have signed, meaning the East African courts, East African countries, have signed to take certain matters to that court. So when a matter is filed before them, I think they go by the same principle we do, that we allow people to file matters, to seek redress from us. But whether they will succeed in that redress or not, I think is an issue again for the courts. Yeah. So the courts are on a case-by-case basis, because if we generalize, then it would be we'd be locking out some people. Yes. Yeah.
So does it mean that when one exhausts all the channels of appeal in the country, then
you can go? And I think people even go international. There are even other courts internationally where one can go.
Okay.
But as to whether you will succeed or whether your matter will be the doors will be opened, again, those courts make those decisions.
All right.
Yes.
I'll take you back to how just the judiciary is preparing to deal with the backlog of cases, which has been quite a challenge. In terms of, if you assess what has caused this, what are some of the main things that you'd cite as the biggest contributors to, the judiciary having such?
The backlog. I would say, first of all, it's the information.
Sorry to cut you short. We're coming back to just pick up on that point. Right now, I'm told, let's just cross over to listening to an update on the ongoing preparedness for covering the 2022 general election from the Independent Electoral and Boundaries Commission. Currently speaking is the chair of Fula Chebukati. Let's listen in.
Negative. They are focused, and where we are today, with a few days to go, Tuesday next week, Kenyans go to the polls. We have prepared everything that needs to be done. What we are remaining with some logistical issues which we are finalizing, and training of poll officials. So these are your people on this very ground. We shall be here next week, and we shall finish the journey that we have been working on for the last couple of years. So thank you very much, and please be seated. So today morning, it's not my day. Mine is just to say thank you for all of you for braving this chilly Nairobi weather. It's very cold outside there. Your being here today is a testimony of love for your country. Most probably you would be somewhere in the comfort of your office or your house, but you chose to be here today.
Imam Kanongula, I request to move ahead.